Good afternoon. Thank you for joining us today and welcome to our SNOIP webinar. Our topic is effective strategies for overcoming trademark refusal in Thailand. We are excited to share our insights and practical strategies with you. Here is our agenda. If you have any questions during the webinar, please feel free to send us an email. Before we begin, I would like to introduce our speakers and our firm. I'm Nas Pattariya Sirinanthapapakorn, a senior associate and patent agent at SNOIP Thailand, having over 10 years of experience in IP. I'm a certified Thai lawyer, a registered notarial services attorney with the Lawyers Council of Thailand, and a registered Thai patent agent. So my main focus is trademark and patent prosecution in Thailand and Southeast Asia. Next to me is my colleague, Pam, who will be a speaker today. Pam, please introduce yourself.
Thank you, Nas. Hi, everyone. I'm Pam Marisala Salangam. I'm a senior associate at SNOIP Thailand as well, specializing in trademark prosecution in Thailand and Southeast Asia. I have been working in this field since 2015, and I hope I can share you valuable insights with you on understanding trademark refusal in Thailand through our webinar today. So let's get started.
Now that you know more about us as speakers, let me introduce our firm briefly before we start our webinar. SNOIP is a full-service intellectual property firm. We assist clients in registering and protecting trademarks and other intellectual property throughout the Asian countries, Greater China, and Eurasia. SNOIP teams in office across the world have over 25 years of experience on the ground, with over 200 IP dedicated team members. SNOIP specializes in trademark prosecution and trademark portfolio management. Additionally, we focus on IP enforcement actions and implementing customized enforcement strategies, especially targeting cross-border infringements and complex criminal IP cases. Let's begin. Thailand follows a first-to-file system for trademark registration. This means that even if someone else has been using the trademark in commerce before the application is filed, the priority of rights will be given to the first application who files the trademark registration. However, as Thailand accepts the Paris Convention for the Protection of Industrial Property and a member of the WTO, the owner of a trademark that has been filed or registered in a country that also signed the Paris Convention and or is a member of the WTO may claim the first foreign filing date as the filing date in Thailand. If the application is filed in Thailand within 6 months from the first filing date, there is no requirements to use the trademark or submit evidence before the registration is issued. For the trademark registration procedure, there are 4 main procedural stages in Thailand. First, filing. Second, examination. Third, publication. And the last is registration. Today, we will focus on filing an application and examination. Through the chart, you see that after filing a trademark application, the trademark registrar will carry out both formality and substantive examination to assess whether the application complies with the requirements of the Trademark Act. If the trademark is rejected based on formality ground, the applicant needs to file an amendment within 60 days from the date of receiving. And if the trademark is rejected based on absolute ground or relative grounds, the applicant needs to file an appeal against the refusal to the trademark board within 60 days from the date of receiving. And in case that is accepted or successful, the trademark application will be published. Next, I will lead you to understanding the types of trademark refusal in Thailand.
Before we get into a specific ground for refusal, it is important to understand the overall framework of trademark registration in Thailand that has mentioned earlier. The DIP, or the Department of Intellectual Property, is responsible for trademark application. A trademark can be refused at different stages, as you can see here. The first, formality grounds; second, absolute grounds; and the third, relative grounds. Let's start with the formality grounds for refusal. Many of you may have encountered the refusal relating to formality grounds for both international registration or IR and national application, especially concerning the description of goods and services. First, it's important to understand that for national application, the application must be completed in Thai and must be accurate. If you forgot to provide a detail of description of something, it will be lead to refusal. Additionally, for IR application, when designated in Thailand, the Thai register will have to translate everything into Thai before examining the application. Now, let me explain why we sometimes receive the refusal. For IR application, or when you have multiple local agents helping you file the trademark in Thailand, there will be differences in transliteration of the name of the applicant. This can result in the refusal stating that your application is rejected due to the similarity to the prior mark, even if it belongs to the same applicant. However, this refusal can be overcome by filing an amendment and submitting their explanatory letter to inform the register about this situation. Another common reason for refusal is requirement. We require a notarized power of attorney. A scanned copy is available, and 90-day late submission is available as well. However, please remember that for some cases like opposition procedure cannot, the notarized POA cannot be late filing. And remember that notary public who notarize the POA doesn't have to be the same nationality as the applicant as it used to be before, but it must be the same country at the time of execution. For example, if you are a US citizen but in Japan, a Japanese notary public can notarize your power of attorney for Thai trademark application. Lastly, let's discuss about the description of goods and services. The DIP provide the link here that show the acceptance of description of goods and services. While Thailand adopts the needs classification, but specification has to be clear and specific. Broad terms are not allowed. For example, here, if you enter this link, it will show you the description of goods and services. On the left, you will see the description in Thai. In the middle, you will see in English. And on the right side, you will see the classification. We will for example, if you want to file dietary supplement in class 5, in some country, it is acceptable. Instead, it's not acceptable in Thailand. You should specify detail like if we search, it will show up the acceptable suggestion. For example, you have to specify as mineral dietary supplement or wheat dietary supplement. As you may know that Thai register are very particular about list of goods and services. Broad term like clothing, footwear, headgear, or cosmetic will be rejected. However, overcoming this office action is straightforward by filing amendment. But remember that the response examination time frame is currently approximately 6 to 10 months, but this period can be shorter if we keep following up with the registrar in charge. Next, we have absolute ground for refusal. This related to inherent characteristic of the trademark itself as required by the Trademark Act. The mark has to be deemed distinctive and not prohibited by law. The first one, lack of distinctive. So the mark must be capable of distinguish the goods and services from one entity from those another. So if you want to register the mark called shoes for footwear, it will be rejected. Or the mark that describe the goods and services. For example, if you want to register the mark cold and creamy for ice cream, it will be rejected as well. Or using the term 100% pure silk for the product that actually synthetic would be refused as well. Or prohibited by law. For example, you use the offensive term or contrary to public policy will be rejected. Or even you use the official symbol such as national flag will be rejected as well. So understanding this absolute ground will help you decide trademark before register. Nas will explain more about the new examination guideline that were used by the register.
I will speak about the Thailand examination guideline, which became effective in 2022 and related to absolute ground. One of the substantive requirements for a registrable trademark is distinctiveness. The examination guideline explained the character of a trademark that should be deemed distinctive as specified in Section 7, Paragraph 2. A trademark that is considered fanciful, arbitrary, or suggestive will be registrable. Furthermore, the criterion for acquiring distinctiveness through use, according to Section 7, Paragraph 3, requires evidence to be provided to prove the use of the trademark. However, to determine whether a word, phrase, or device has a direct reference or explanation of the character or quality of goods or services, the registrars will use their judgment on a case-by-case basis. Under the current trademark examination guideline, marks contain foreign characters such as Korean, Japanese, or Chinese characters will be considered distinctive and registrable as long as the mark as a whole renders no meaning. Abbreviations and acronyms of words with meanings. If they have multiple meanings and one of those meanings directly refer to the characteristic or quality of the product, should be considered as having no distinctiveness. For example, the word max is an abbreviation of maximum, and the word bro is an abbreviation of professional. These abbreviations can be interpreted to mean if they can immediately convey to consumers or with minimal discernment the characteristic or qualities of the product. Therefore, those words are considered to directly refer to the characteristic or quality of the product. A combination of two or more English words with dictionary meanings will be divided into individual words and examined for distinctiveness. For example, clear view can be translated to mean clear vision, and when used for contact lens products, it implies that the contact lens provide clear vision directly refer to the product's characteristic. Ham will provide a sample on distinctiveness.
In addition to what Nas mentioned, the register now recognizes combination of letters and number with three or more character as inherently distinctive, unless they form common sequence like 1, 2, 3, or ABC. So before this new examination guideline came into effect, the mark consisting of three standard letters were typically rejected unless it's represented in stylized manner. For example, you can see here the two mark is belong to the same applicant. The mark on the left, BXP Digital, is got rejected by the register because it was filed in 2018. And the register viewed that the term BXP is not represented in stylized manner, and the term digital is descriptive. However, in 2023, the client refiled the non-stylized mark BXP and it was successfully registered. So if you have non-stylized three-letter mark that were rejected previously, we recommend refiling them as soon as possible to ensure your mark is protected. Because filing an appeal against this absolute ground refusal now take approximately 3 or 5 years for examination due to like a current backlog. Therefore, please ensure you are prepared to wait that long to get the mark registered. So I will pass to Nas on our last ground.
The last type of trademark refusal we will discuss is relative ground, which is a citation. This refers to whether the mark is identical or similar to a prior mark or a well-known mark. The registrar will examine for prior rights during the examination of an application for registration and cite such prior rights if raised. Prior rights include any prior identical or confusingly similar trademark in the same class or in a closely related class having goods or services of the same character. The registrar will raise a citation where the goods or services claimed are clearly similar and they have supporting reasons to be convinced that deception or confusion will likely happen to the public if the trademark are utilized by different proprietors in relation to those goods or services. The assessment of similarity for each type of trademarks requires considering consumer group, whether goods or services require supervision by experts, purpose of use, channel of trade, and price. Broad deception of services and more specific goods are considered as not overlapping. Even if the compared trademarks have no different features when viewed side by side, if both trademarks contain the same idea, and the public may remember the trademarks by the idea generated rather than by the overall features of the trademark, use of such trademark may cause confusion to the public and lead to rejection owing to deceptive similarity of the trademark. If the registrar raised relative ground for refusal, we can find appeal including argument or evidence to demonstrate that there is no likelihood of confusion, showing differences in the goods or services or the markets in which they are sold, and also presenting evidence of coexistence without confusion. I would like to emphasize that a letter of consent or a coexistent agreement from the owner of a prior trademark cannot facilitate the registration of another trademark owner's subsequent registration. However, as an exception under Section 51(1) of the Trademark Act, the registrar may accept a letter of consent only if, in the event that the citation is a result of an assignment or assign-back procedure. As the relative ground is accessed to prevent the likelihood of confusion among consumers regarding the origin of goods or services. Before filing an application, we suggest conducting a similarity trademark to identify any existing trademark that might conflict with the proposed mark, and then evaluate the likelihood of confusion by assessing whether the proposed trademark is similar to any existing trademark in terms of visual appearance, phonetics, sounds, and conceptual meaning, and also evaluating the similarity of the goods or services associated with the trademarks. And we'll now discuss the Madrid system and national filing.
Thank you, Nas. So let's explore the differences between Madrid application and national application. As you can see here, the examination state for both the Thai register combine both formality sub-examination and substantive examination only one step. But for the time frame is different. It takes approximately 18 months to issue a provisional refusal for IR application compared to 12 months for national application. This is because I mentioned, the register have to translating or application name and address and list of goods and services into Thai for examination purpose first, and then they will base their view on this translation. That's why it's caused a delay. Therefore, if you seek a quicker process in Thailand, filing a trademark through Madrid might not be the best option. However, DIP has adopted the fast-track examination for trademark application and renewal. For new application, if your conditions are met, for example, you have 10 items of goods and services, and using the description from Thai trademark classification that I showed you previously, you can receive the first office action or your publication within 6 months instead of 12 months. Unfortunately, these fast-track routes are available only for national applications. Requirements for both Madrid application and national application, we require notarized POA as well, and 90-day late submission is available. Primary rejection is only available for amendment for Madrid application, but not available for national application. For national filing, you have 60-day deadline to respond to office action, whereas IR application have a 90 days deadline. Regarding the certificate, so if your application faced refusal and local agent is appointed for Madrid application, the DIP will issue statement of grant to WIPO and the certificate will issue to the local agent. But for application that not facing provisional refusal, there will be no local agent and the DIP will only issue the statement of grant to WIPO without issuing the certificate to applicant, to local agent or applicant. Applicants may request the certificates from the DIP as an evidence of registration, especially in the case of infringement, because some enforcement authority may require such document as evidence. But due to the number of certificates to be issued for Madrid application right now, there will be delay in issuing such certificates. But in any urgent case, applicant can obtain a certified extract as evidence from the DIP. So we recently obtained a certificate of registration called CM2, issued in English, like show detail of the applicant, the status, and list of goods and services. Will take approximately 7 days to be issued from the DIP. And if your mark isn't rejected, filing to WIPO or Madrid as an international registration can be very quick. Likewise, filing a trademark through national application can also be fast because we adopted an efficient fast-track system. So key takeaway from today's webinar is, as Thailand adopts first to file system, so we suggest everyone file their mark as soon as possible, but consider the comprehensive trademark search first prior to filing to aware of the prior mark or citation. Consider the mentioned refusal that we have mentioned before prior to filing, and consult your local agent or us if necessary. If you have remaining question or any inquiry regarding the intellectual property matters, please don't hesitate to contact us. Let's us check our email box to see if we have any question. Oh, some of question needs comprehensive advice, so we will reply to you after our webinar. As we only have time for only one question, we would pick one question here. So the question we have here is, if refusal rejected only some goods and services, and the applicant does not respond, will the application be deemed abandoned? So my answer to this question is, if the refusal applied to only some of goods and services list, but no rejection on non-distinctive or disclaimer or anything, just only for the goods and services, and the applicant does not respond, the application can still proceed with the remaining goods and services. So you will get protection only the remaining goods and services. We hope this webinar has provided a valuable insight and strategy for navigating trademark refusal in Thailand. If you have any further questions or need assistance, please don't hesitate to reach out to us. Thank you for your time and participation. We look forward to working with you and supporting your intellectual property needs. Thank you.